So our next segment, I think, do you want to introduce Adrian? I got Adrian. Okay. Adrian Karborani from Robert Allen Law is our designated guy at IYBA. Bob Allen's been a great supporter, and all of the partners at Robert Allen Law have been great supporters of IYBA for quite some time now. Adrian is my guy. I talk with Adrian, 3 times a week, 4 times a week. We talk about forms. We talk about making sure that the protections are in place for you. We talk about liabilities with yachtbroker.org and with boatdocs.org. We talk about all kinds of legal concepts and things. Adrian's the gentleman who's been charged with doing all the updates to our forms, the actual practical application of those updates. That information comes, John, stick your hand up. John Burkhardt from Allied Marine, myself, I've been chairman of the Forms Committee since I didn't learn to step back when they asked for volunteers. So since 2009, I've been basically running the Forms Committee along with John's help, and Rob Moss and Bob Allen and Chris Anderson have been super, super helpful in developing a great foundation and platform for you to do your business. Adrian, come on up here and let's tell everybody about the differences in the forms and what changes we've made and why. You can give him a round of applause, or me, either one.
Morning. Good morning. Thank you, Paul, for the introduction, and to the IYBA for inviting me to speak here today as the first guest speaker, which can only mean one of 2 things. Either Paul and the team really dislike lawyers and they wanted to get one of us out of here as soon as possible, or they expected most of you to arrive after 9:30 and save you the suffering. I'm just kidding. Probably means they wanted to torture you a bit. So, all bad jokes aside, this morning I'll be covering the revisions that have gone into the latest few iterations of the IYBA forms, specifically the purchase and sale agreement and the listing agreement. But before I begin, I wanted to warn you that there's going to be a few shameless plugs that we will get to right now. So if you weren't aware, the latest versions of the forms we'll be discussing today are available for you to download on your member portal. Just navigate over to your dashboard, find the drop-down box on the right-hand side titled Document Library, and you'll have access to all the latest versions of the forms. I also wanted you to know that updates to the forms are typically made more than once per year because of the feedback you're regularly providing the association. So when an update is released, there will usually be an article in Compass that coincides with an upcoming or recently implemented change that's tucked into a section fittingly titled The Law. Anyway, without further ado, let's jump right in. So today we'll be discussing a few topics. The first 2, dispute resolution and conditional acceptances, are more involved, so we'll spend a little more time on them. And we'll finish up with the second 2 topics, Spanish forms and additional parties, which require less explanation, but I wanted to make sure you had some exposure to them. So turning now to dispute resolution. Shortly after the last East Coast Yacht Sales Summit, we released updated versions of the purchase and sale agreement and listing agreement that changed both the substantive provisions of the dispute resolution clause and the default selections. So let's take a quick look at the old dispute resolution clause, and then we'll compare it with the new version. And although the following examples are going to be coming directly from the PSA, these changes apply equally in the listing agreement. Okay, so you don't have to read that. I'm just going to give you the short rundown of it. So this is section 17 from the 2020 version of the IYBA PSA, and it gave you essentially 3 options to choose from. You had the choice of either A, traditional litigation in the courts located in the state of X, with X usually being the state of Florida. B, binding arbitration before the American Arbitration Association in the state of X, again with X typically being Florida. Or C, binding arbitration in London, England before the London Maritime Arbitrators Association. However, in most cases, the default selection, meaning you left section 17 alone and didn't check any of the boxes, you'd end up resolving any dispute in the state or federal courts located in Florida, applying Florida law, and venue somewhere in the state, usually right here in Fort Lauderdale. So the new Section 17 changes both the available options and the default provisions. So you now have two choices. You either have A, binding arbitration before the International Yacht Arbitration Council in Fort Lauderdale, London, or Monaco, or B, binding arbitration before the London Maritime Arbitrators Association in London. If you select the IYAC, you have the choice of applying either Florida or English law, and if you select the LMAA, you'll be applying English law. And if you leave the section blank, the default will be to resolve the dispute before the IYAC in Fort Lauderdale, applying Florida law. Of course, you can always decide to modify these provisions, either choose a different venue, different arbitral body, or go back to the courts, but you'll have to handle that by addendum. So you might be wondering, which one do you pick? Well, that is going to vary deal by deal, and unfortunately, there's no one-size-fits-all answer. You'll definitely want to consider who the buyer and seller are and where they're located. You, as the broker, where you're located and where your colleague on the other side is, and of course, where the yacht is. You'll also want to consider which law would give you a more favorable result in the event of a dispute, but that's really a conversation you're going to want to have with your client's attorney. What I can tell you is that generally selecting, or rather not selecting, any of the provisions and letting the default mechanism control will usually be a pretty safe choice, because you'll be applying Florida law, which is pretty balanced. You'll be in here in Fort Lauderdale, and you'll be before the IYAC. So let's turn a little bit to the IYAC, if you haven't had any exposure yet. So why make the change from traditional litigation in state courts to arbitration? Well, there are four primary reasons, all of which are generally true of arbitration, but one that really hits home in terms of the IYAC. The first is speed. Arbitration is faster than the court system, and in this business and the type of assets we're dealing with, this is extremely important. Second is knowledge and expertise. Arbitrators are usually hand-selected for their knowledge and expertise, and especially in the case of the IYAC, the arbitrators are highly experienced in the yacht business. Third is privacy. Arbitration is private as opposed to court proceedings that are open to the public, which will likely be a very important consideration to your client. And fourth is cost. Arbitration is generally more cost-effective than court hearings due to the governing rules that limit the procedural aspect of it, namely the discovery process, which is the most expensive and timely part of litigation or other dispute resolution. So if you haven't been exposed to the IYAC, the next couple of slides depict some of their arbitrators. I just took snapshots from the top of each page for each region on the website, and didn't mean to leave anybody out. So you should go ahead and take a look at the page when you get a chance at iybac.org to get to know more about the council and the arbitrators. And if you'll notice, I guess the font's kind of small for some of you in the back, but the arbitrators are not just lawyers. They're industry professionals who have worked in this field, many for decades, and know the business. So to return to the question, why arbitration over the courts, I'll let you answer that question yourself by posing one of my own. If you're purchasing a home, would you go to a personal injury or a real estate lawyer? Both are legally educated, trained, and licensed to practice law, but you'd probably choose the real estate lawyer, right? The point I'm making is twofold. First, an expert in a certain field is much more likely to deliver a better result than someone who has little to no experience. And appearing before an expert makes it easier to argue your case and requires less time spent on educating someone of concepts that are common to our industry, so you can focus your energy, time, and money on the crux of the matter. Second, just because someone is educated in the law doesn't mean they can effectively, nor should they, ideally, decide every area of the law. I mean, it's the same for doctors. You wouldn't go to a podiatrist if you had a broken nose. Essentially, the change was a no-brainer. It just took a ton of hard work from many people who are right here in this room to make this an option for you, the members, and the other individuals who work in our industry. So let's shift gears now and talk about a small, literally one sentence, but significant change regarding conditional acceptances under the PSA. So on the screen is the revised section 3 of the PSA, the only change being the portion highlighted in the center, which reads, an acceptance subject to any conditions will be deemed a proposal to amend this PSA and will not preclude the buyer from accepting the vessel unconditionally on or before the accept-reject date. So why this change? What does it mean? Well, there are two reasons for the change. First, from a legal perspective, submitting a conditional acceptance can operate as a rejection and counteroffer under the old PSA. I'm going to save you the law school lesson and give you the Cliff Notes version. Acceptance, a conditional acceptance without the revised language in the PSA can be deemed a rejection of the yacht. The simple act of sending a conditional acceptance could literally kill a deal. So the first reason for the change was to address the potential legal implications of submitting a conditional acceptance. The second reason was to curtail, for lack of a better word, bad faith on the part of the seller. At the time when the buyer is ready to tender acceptance, he or she has already spent significant time and money evaluating the yacht for purchase, and in some cases, a really significant amount of time and money. The fact that a buyer may approach a seller and ask for something that was unknown to them before contract, for example, fixing an item on the yacht, a price adjustment for survey deficiencies, or some additional documentation because of the vessel's class or size, should not give the seller a right to back out and walk away. The guiding principle, if you will, is what one person has asked of another in good faith, negotiation should not prejudice them from moving forward if the other side does not want to agree. And the parties who enter an agreement should do so on the basis of good faith. This change, as one person said to me, and I totally agree, is that this change will turn the tide of the industry. So while the change is small, it is significant and helps to better preserve the deal and good faith dealing. So let's turn now to the new Spanish forms. The association has taken a giant step forward in expanding its international presence by delivering to you official Spanish versions of the listing agreement and purchase and sale agreement. These new forms are substantively identical to their English counterparts and will help to support many of you with Spanish-speaking clients. So how should you use these Spanish versions? Well, just like the English versions, you're going to go ahead and fill out all the yacht details at the top, fill out any of the remaining portions of the form that you deem necessary, and then you're going to have your client sign both the Spanish forms and and sign the English version that's attached at the end. And I'll get back to that in a minute on why you want them to sign both. A word of caution, though, if you are using an older version of the agreements on your brokerage's letterhead, relating to the English version, that is, the revision dates at the bottom of the page in that eye-straining 7-point font needs to match exactly on both versions. And so the easiest way to ensure that you have the latest version and that they match is to download, again, another shameless plug, download them from your document library located on your member portal. So going back now to why the client has to sign both the Spanish and English forms. A couple of issues had to be resolved and considered when translating the forms. So first, we had to deal with arguments over interpretation, since the agreements are now in another language. And second, we had to figure out how to handle formal disputes, since as we just discussed, the IYAC is now the default dispute resolution forum, applying Florida law and usually in Fort Lauderdale, Florida. So how would the IYAC be able to continue to resolve disputes involving a contract in another language? Well, typically, the petitioning party would have to engage a translator and revert the agreement back to English and hope the other side agreed with the translation. So as you can imagine, it could get pretty messy. So what we did is, we included language in the Spanish version that states that in the event of a dispute as to the interpretation of the agreement, the English version will control. And the English version is annexed to the back, as I mentioned before. It really was a simple fix, but just requires you to get a few more initials and a signature from the parties. And that's about it for the Spanish form, so let's turn to our last section, which is probably going to take about 20 minutes to cover. Additional parties. You can now list 2 buyers and 2 sellers on the forms at the request of the membership. This is currently live on the PSA and will shortly be added to the listing agreement with, I believe, some other revisions that are going to be going through shortly. So I'm sorry my attempts at humor are really bad, but thank you guys for putting up with me and letting me spend this morning with you, and I hope you found this informative. Happy to take any questions.
I think that's amazing, Spanish class. Why would you even put like English and the Spanish right under it? So it's all one form instead of making it 2 forms.
So the question was, why didn't we put the English language directly under the... Oh, the amazing part. So the question is, why didn't we insert the English language directly under the Spanish language in the form? So it wasn't something that we initially considered. We wanted it to be read in whole as one cohesive document and just have the, in terms of interpretation, be governed and controlled by the English form. So the parties, potentially, if you had a Spanish-speaking client and there were multiple, there was an English version and a Spanish version in the same document, could be confusing. So that was one of the considerations. But I mean, we're always taking suggestions and making changes based off of the membership, and I think that, you know, that's something that we can consider. Oh, I did a great job. Well, thank you guys.